Oh, thank
I'd
you.
get one of those. Good work.
All right, folks, good afternoon. I'm going to give it one more minute to get more folks dialed in, and then we'll get started. All right, I'll be true to my word. Give it one more minute. Can I get a thumbs up out there? Can somebody hear me? We're good? Excellent. Thank you. I appreciate it. Hey, good afternoon, everyone. I'm Chris Allen. I'm the director of the Kentucky Intelligence Fusion Center, and I'm the acting executive director of the Kentucky Office of Homeland Security. And today, it's my honor and pleasure to talk to you about open records requests, and again, just try to baseline, what the requirement is and some of the things you should be on the lookout for as you field these requests and you respond to them. So. All right, and I already have somebody out there with a hot mic, so we might have that a few times, but if y'all could just make sure your mics are muted, I appreciate it. All right, so let me pull up my slides and we will get started here. All right, so like I said, I'm with the Kentucky Intelligence Fusion Center, and we'll start with that. A little bit about what we do here and why that pertains to open records requests. We're one of the partnering offices here within the Kentucky Office of Homeland Security with our 911 Services Board. And we're basically here to share information on threats and hazards. And we work with our federal, state, local law enforcement, public safety partners to make sure we get the right information to the right people so they can make timely decisions to address any threats or hazards. So that's what we do. That's the team that I lead here in particular. We're a lean and mean team of a handful of analysts that do this day in and day out, but we enjoy what we do here. And again, we enjoy our partnership with our 911 Services Board, brothers and sisters here within our office as well, and want to enhance that collaboration even further. And if we can do a little bit of that by helping out today with this session, I'm more than happy to do that. A little bit briefly about me. Started in this job about 13 months ago. I'm a retired United States Air Force officer, served for about 23 years. I was a federal agent for the Air Force, and then I finished up as a cyberspace operations officer. I'm also a licensed attorney in the Commonwealth of Kentucky, as well as a licensed private investigator. So I do have an intimate familiarity with both fielding as well as requesting open records from various state agencies. So hopefully that helps with a little bit of context to why I care about this topic the way I do. All right, so let's just dive right in. Here's what we're going to be talking about. And we're going to be talking about what the heck are open records requests, and I'm presuming a lot of you have seen these, but if you haven't, or you just don't have a real good comfort level with what these entail, hope to remedy that a little bit today. And I will say up front, this is just a conversation starter. If you ever want to pick my brain at some point going forward, feel free to reach out to me via email or hit my phone up. I'll be happy to field any questions you might have. I will say up front, as I'll say at the end, these are my thoughts and opinions on open records requests and my interpretation of the statutes. They're mine alone. This is not an official stance. I'm just here to try to be helpful in any way I can to help broaden an understanding of what these requests are and the requirements that you have to respond to them. But we're going to go over what open records requests are, what the response requirements, what they are, and then what kind of release criteria you have to have, that whole pesky adjudication and legal review process to make sure that you're responding appropriately, and then just kind of go over what the opportunities to inform are with using open records requests to do that. And then, like I said, having been on the other side of it, I'll give you a little bit of perspective of what these look like from the side of the person that's actually sending you a request, and hopefully help you understand, just what people are actually looking for when they don't necessarily have an ill intent, or they're not looking to clog up and waste your time, because most folks are not looking to do that, but you will get folks like that from time to time, and there are ways to address that. And then we'll finish up with giving you all an opportunity either through the chat or with just chiming in to ask any questions, and I'll do my best to field those. And if I can't field them today, I'll certainly circle back with you. I'll go back through Mark Gauss or Shelley to get you the answers that you seek. All right, so let's talk about what are open records requests. And this all comes from Kentucky Revised Statute, right? And in particular, 61.872. And that basically means that what are defined as public records, these are supposed to be open for inspection by any resident of the Commonwealth of Kentucky, except when there's some kind of exception provided within the statute. And what folks are required to do is make a written request or an application to a particular public agency. Those are defined as well, and I'll pull some of this up here in just a second. They're supposed to make these records viewable or the ability to obtain copies of those records to the individual requesting them. There is a kicker, right? There is the residence requirement. This statute is a state statute, and as such, it is limited to enforcement on Kentucky residents or providing that service to Kentucky residents, and that is defined as well. So you want to be on the lookout for those kinds of requests where you're not seeing any indicator whatsoever that somebody is an actual Kentucky resident. But there's also an interpretation factor there. I'll just point out now, while you may request some kind of statement or something that indicates that whoever's requesting these records are somebody from Kentucky or an actual resident that meets the statutory definition of a resident in Kentucky, you can't necessarily demand proof of that. And that's where, as you go through this process, and I'll say it once, I'll probably say it several times, you want to be in lockstep with whomever your servicing legal advisor is to make sure you're being responsive in the way that you're required to be responsive. And then there's a timeliness aspect, right? You're supposed to respond to these within 5 days, and that's typically 5 business days. We're not talking holidays, we're not talking weekends, but 5 business days. Used to be 3. It's been changed, and last several years, my understanding, was changed to 5. So those are kind of the big ticket things when it comes to what are open records requests. And what I want to do at this point is I'm going to pull down the actual statute so you can at least see what that looks like. And let's see if I can pull that over real quick. Bear with me if it'll let me share it. This is always fun. Looking like we're sharing. Okay, you should be seeing KRS 61.872, and that's where it gets into the residency requirement. And this is where you can take a look at that. Again, with any kind of statutory language, there's a little bit of legalese involved and that kind of thing. But I always like to point people to the source document for whatever the requirement is. Feel free to go back to this, refer to that, and then I'm going to show you another document. I actually sent you a link to it, a couple of documents in the chat. I think a really useful product, and the various attorney generals over the years have saw fit to update this. They have a document on their website, and again, I put the link in the chat, laying out a guide for open records as well as open meetings. So really for our conversation today, it's about the first 20 pages of this document, this guide from the AG's office, that are applicable, and it puts it in a little more plain language as opposed to the statutory language. So I think that's helpful. And what's really helpful is at the very end of the document, it gives you some, what a sample application for an open record would look like, and then what a sample response letter would look like that you would want to send back within that 5-day period. So I think it's a really useful document and something you could peruse as well. But feel free to copy those links and put those in your file so you have those handy going forward. All right, let me pull back up the slides and we'll keep going from there. If I can get that to work. Here we go. Now bear with me. Driving my own ship today. All right. So we talked about what open records requests are. And the next one is the response requirements. Actually, before I do that, let me go back to one other note that I think is subject to interpretation. Let me go back to the previous slide here. That residency requirement, right? The statute lays out what those requirements are. Another aspect of that is for media queries. So a news gathering organization, and it talks about that. And that can be defined strictly or broadly. I know currently for our organization and our office, we tend to be a little more broad in our perspective of what a news gathering organization might be. But I'll leave that to your organizations and your lawyers to kind of determine what the acceptable bounds are when you get a query in from a news gathering organization that may not have an in-state Kentucky address or any kind of indicator that they have some kind of tie, strictly speaking, to the Commonwealth Attorney, or Commonwealth of Kentucky. My apologies. So that's one where you probably have to have a little bit of interpretation. But I know, again, from our office, we tend to interpret that a little more broadly and give a little more leeway if it's like a media request for information. All right, so for the response requirements, you want to make sure that you're confirmed. This is a valid request, right? You've received something. Is it a valid request? And I just talked about the residency aspects of that. Is it a request to your agency, which I'm going to assert for 911? You are public agencies, according to the statute. You fit the definition of a local or a state agency that is required to be amenable to these kinds of requests. But are these records within your control? And do you have a designated custodian of records within your office? And in smaller shops, I understand you're going to wear multiple hats. Oh, I didn't even realize I was supposed to be a records custodian. Well, now, congratulations, you got another duty. But you want to make sure that's actually something that you can access it. And if it's not something that you or your agency, your office can access, that's a rationale to go back in your response and say, sir or ma'am, we don't have this. Respectfully, you need to go look for this in another location. And your response requirement is then complete, right? But you want to make sure that you're not using that in the wrong ways, and when in fact you might actually be the responsible agency. So again, when in doubt, consult your lawyers, but that's a good rule of thumb. Are they a resident? And is it actually a record that you would have within your control? And the statute actually goes into the different types of things that you would have. That would be something that you would have control of and the ability to release. Documents, your call logs, dispatch logs, even recordings. And again, with any of this, when in doubt, when it comes to the sensitivity or the level of detail, you might put in your own policies and procedures as to what you're comfortable releasing in consultation with your lawyers, but you want to at least meet the minimum standards of the statute so that we're meeting the intent of the statute, which is to be transparent with our state or locally controlled information. Does somebody want to view the information, or do they want copies? The viewing part is probably more tricky, because if you're in a smaller office, you might not necessarily have an office space or a little room where you can allow somebody to come in and look at documents, or even sit with a headset and listen to call recordings, right? Mark, go ahead. I'll pause here.
Yes, you have two questions here. Do we have to honor verbal requests?
That's a great question. I think you are on safe, solid ground if you insist upon putting it in writing. And where it gets a little tricky is when you have walk-ins. So if you have somebody that walks into your facility and asks you for information that you do actually have, you are the custodian of record for it, what I would say is have some printouts of a sample request form that somebody can fill out on the spot. That way you save yourself some heartache. You save somebody from getting in an argument with you, any of that kind of stuff. Well, I'm a resident. I'm lawfully entitled to this. I look at the statute. Yes, sir. Yes, ma'am. Sounds good. fill out this form and I'll be happy to respond to you within the 5 business day requirement, right? I think that's a better approach. But in terms of somebody calling up and requesting that, you don't have any way to verify residency over the phone, realistically. I would insist upon something in writing. So you're wanting to get these through a letter, through an email, or like I said, if it's a walk-in kind of scenario, and whatever situation that might be, I'd have them fill out a form right there on the spot. The other question, yeah, Mr. Cox, that one gets a little dicey. That's where it kind of threw me for a loop as well. All right, well, we're required that they be a resident. How can we confirm that? And I think, again, that one, you could go back to the Attorney General's office, and I think the interpretation is, from their perspective, you want to have something in the letter, whether that's an address or somebody flat out saying, I'm a registered voter in this county, or I live in this jurisdiction, that indicates that, yeah, that sounds like they're a Kentucky resident. You're going to be on the lookout for that. But in terms of going back and demanding proof, I think what it's really getting at is you're not going to be demanding, like, I need to see your driver's license. I need to see your birth certificate. I need to see your social security card, or just whatever, any of those kinds of things. I think that's where they're trying to get people away from doing those kinds of steps, just so you can avoid putting people in situations where you're demanding information that you shouldn't necessarily have access to as well. But it's a delicate dance. It's a great question. That's one I also have as well. But that one also ties into the media thing, because I get tied in knots about when I get requests from media outlets, and I'm like, man, this one really feels like this might be AI generated, or this is somebody that's not who they're portraying themselves at. It's a judgment call. And it really goes back to what your agency is comfortable with, your interpretation of the statute in conjunction with the lawyers that are advising you. That's probably the best answer I can give you. And as long as you're consistent, I think the big ticket thing here is being consistent in your review process and in your adherence to whatever interpretation of the requirements that you use. I think that's going to keep you on solid footing as long as you do those things. But great questions, and keep them coming. But the viewing aspect, whether you're providing copies or viewing, just be aware that that's a dynamic that you'll have to deal with if you're okay with, or you're intending to meet that requirement. Because if somebody wants to walk in and view stuff or listen to stuff, by statute, you're supposed to make that allowable. Maybe another alternative is to, hey, actually, there's another office a couple of doors down or whatever that we let folks do that. But I would just say you need to have some kind of logistical way to make that opportunity a real opportunity for folks. And again, inspecting records within 5 days, not to exceed 5 days from the date that you receive the application. And I will pause on this one to say that it is okay to come back within that 5-day period and say, listen, it's actually a valid request. You've asked for quite a bit. It's specific enough that we can meet your request, but we're a 1 or 2 person shop. That's all we have. It's going to take me a minute. I am going to respond fully, and we will respond as expeditiously as possible. But it's going to take us some time. Right. And just having that honest, transparent communication, I think you meet the intent of the statute is if you're at least responsive within that 5-day window, and then you give updates subsequent. But again, you can go back through your lawyers and make sure that everybody's in agreement that that's the right perspective. But I know that I've seen that, because I don't always get, when I've requested information, they don't always meet the 5-day window, but 9 times out of 10, somebody's writing me back saying, we're going to meet this as soon as we can. It's going to take us a while to pull these documents, and we'll get it back to you as soon as possible. You just want to be responsible and let somebody know that you received it and that you believe it's a valid request, and we're going to answer as soon as we're able. All right, so let's talk release criteria. And there's a couple of statutes appropriate here, KRS 61.878 and 61.870, which is the definitions. But the bumper sticker for this one is what I have at the top of the slide, which is, you're a public agency. It's a public record within your control, or you're a custodian for it, and there's no exception, meaning there's no exemption as to why you can't release it. And that's where you have to really dig into that guide that I sent you, or into the statute yourself if you want to do that. And you can see, hey, here's the ways in which when we do our review, yes, we have these records, but we either need to sanitize them or redact them, or we're not releasing them at all because we believe it meets one or more of the exemptions. And what you would do is then go back in your response and you would say, we're going to release X, Y, and Z document, but we're not releasing these because it meets one of the exemptions under statute, under 878, I believe, or we're releasing it, but we've redacted it for these reasons. And you just lay that all out there. And as long as, again, you're transparent, you're crystal clear in what your response is, you're on good ground. And the last part of that sample letter that you would see in that guide is also, if you don't like what we're telling you, take it up with the Attorney General's office. You can appeal our decision further up the chain, and you always give somebody an appeal option that will cover you as well. Mark, go ahead.
Another question. If we receive
Yeah.
an open records request by mail and the date on the request is outside that 5-day window, what are we liable for?
So again, I think consistency, which date, or I think from our office, what we're going to go off of is the date we know can receive it. And most of our requests come via email. So there's a time date stamp on that email. I start the clock from that point. If you got it through snail mail, I would start at the date it fell into your inbox. You know, if that's your mailbox, if that's your PO box, whatever that might be, as soon as you pick it up, that's your 5-day window, and that's what you go with. But again, go back to your servicing lawyer and see what they're comfortable with. But I don't know how else to do that, because even a postmark, you may or may not have a time on there, and that can make a difference, right? You know, if we're talking really early in the day or really later in the day, it gives you more or less time towards that 5-day requirement. But I think as long as you're consistent in your approach, that's what's going to matter most, and that you can articulate that. Even better, that your agency have some very, you know, it can be very short. Here's our policy on open records requests. Here's how we're going to handle them. We reference the KRS requirements, but here's how locally we've decided we're going to handle these things. That's another approach that you might consider, again, in conjunction with your with your legal advice. Let me see what this other one is that I'm seeing here.
There are two more after that one, sir.
Quick look.
Should all information be encrypted
Yeah.
and sent via email?
That's a local decision for you all to make. I think it's going to depend on, you know, I'll just tell you from our perspective, if it's we don't have that information, or you don't meet the residency requirement, or it's something that doesn't have any kind of information that's actually going out other than our response letter, there's no reason for me to encrypt it, because one, I want to make sure they actually receive it, because as you all know, sometimes the encryption tools can be a little wonky, and I want to make sure whoever's on the other end, they know I have met my clock, I've met the requirement, I have responded, we are good. But if there is something about it that is sensitive in terms of the response that you're sending back, certainly that is something to consider. And you can find a variety of means or methods to get the information back to the person, whether that's, hey, actually you need to come by and pick up an old school disk with the info on it, or a drive or a thumb drive, or we'll print out the copies. They want to come in person, or if it's somebody that's further away, there are whether encrypted email options or other sites that you can use to make sure that it gets to them and only them securely. But that's a great question, and I like your thinking as a cybersecurity guy myself. And then this last one here, we're talking Florida. Let's see here. Yeah, why are they referring to Florida statutes? Not applicable, since if they're hitting up an agency here in Kentucky, we only care about the Kentucky statute. Call records. First thing, you should always be on the lookout for anything that gives you indicator that they are or are not a Kentucky resident. And if you are not seeing something that gives you that indication, that is a valid response. Hey, we are by statute only required to respond to Kentucky residents. You are free to resubmit an application or a request that indicates that you are in fact a Kentucky resident, period. And I think you're on safe ground. Again, refer to your servicing lawyer for the best way to approach that. But I think that is the safe approach. If you can't meet that initial threshold of the residency, you can, within that 5 days, without any fear whatsoever. I do not believe I see anything here that indicates you're a valid Kentucky resident as required by Kentucky revised statute. Resubmit. If I don't hear anything further, I'll consider this one closed. And I think you're good. But that's a great question. All right, so I'm going to keep pressing on here with the release criteria. Y'all keep the questions coming. The written request or application, it's going to need to contain, again, that residency information, specificity. I can't say this word enough. I'll get tongue-tied if I say it too many times in a row. It needs to be specific. There is actual language in that AG guide, that Attorney General's guide that I sent you the link for, that talks about, let's say in particular, lots of folks, and I've been guilty of this myself, any or all. If you see a request like that, any or all documents, any or all data, any or all, that is way broad, and you can absolutely push back on that and tell them that, hey, you're actually placing an unreasonable burden on us to produce that. You need to be more specific. And as long as you answer within the 5 days that I'm giving you another chance to get more specific in your request, I think you're on safe ground. But you want folks to be specific in the request that they're seeking, because again, the legislature recognizes that there's only so many resources out there to field these requests, and it can't be so burdensome that it basically shuts down your main mission. And in your all's case, your main mission is vital and very important, and every second and every minute counts in being able to do your normal jobs, let alone be able to field open records requests. So feel free to push back on whether something is not specific enough that you would be able to reasonably answer the request. And again, if it places an unreasonable burden on your agency to respond, that is another avenue where you can go, we can't field this as written. Feel free to resubmit with more specificity. I told you I'd get tongue-tied. Or again, we'll view this matter as closed. Another way in which you don't have to deal with these things is if it starts to, I'm not going to use the H word, but it starts to feel like harassing behavior. They're hitting you up repeatedly. They're not actually being more specific as you've asked them. That's another way in which you can, the statute gives you leeway to go, this is disruptive. This is not legitimate. We don't feel that we have to be responsive to this because it's actually a disruptive type request. But I will tell you, you need to be on really, really solid ground to push back for that reason. So again, talk to your lawyers for that. And there's typically like a clear and convincing evidence standard for denying a request for either the unreasonable burden on your agency or that somebody is basically harassing you or being disruptive with the request. Exemptions, those all fall under 61878. There's a laundry list of them. And they will get into, that folks are seeking like competitive advantage, economic information, or they're seeking like state employee testing type stuff, all the way to like law enforcement sensitive type things, sources and methods, and not to mention asking for people's social security numbers or things that are, no kidding, privacy, PII type things. So there are the exemptions. You need to be familiar with those. And anytime you do a review, whether it's you individually or as a team approach, which I highly recommend, that you're looking through those exemptions to make sure that whatever somebody is requesting, it doesn't fall under one of those exemptions. And then if it does, you just document it as such in your response. All right. Adjudication and legal review. As I've said multiple times already, the legal review portion is critical here, so you feel comfortable with the response you're sending back. But you've got your review request. You've kind of navigated through what you think somebody is asking for. You feel like they meet the residency, that your agency actually does have these records. You know what the types of records are that they're asking for. It is something that you can meet. You've gone through the exemptions. You've gathered all these things up. You're starting to just kind of analyze, hey, are we going to be able to respond back with whatever records? You're going over that release criteria. Like I said, you're going over the exemptions. I've recommended that team approach, so you put multiple sets of eyes to catch things. And I know for our office, we deal with information from different levels. It's not only state-produced information. We get things from federal partners or other entities. We don't own those documents, so we don't own that risk in disseminating them. So we don't release them, and we'll put that in our response. Hey, we don't own these documents. You need to go to a federal agency X, Y, or Z, or this other state entity that actually generated this document. So you want to be careful about that too, because a lot of times in various offices, data start getting mixed together, and you want to make sure it's actually owned by your office or produced by your office. I think that might be a little simpler for your all's offices, but I don't want to speak out of turn. It's just something to be aware of. But again, you're engaging your legal advisor when in doubt, when you think there's a borderline issue on an exemption or on release criteria. That's where the lawyers can help you with that. And then lastly, it's crafting that draft written response with that option at the bottom for either within your agency, your county, your town, your locality, what have you, or even the Attorney General language that we use. Hey, you always have the option to appeal this if you want. You always put that there for them because that's a due process kind of thing. You want to have that in there, but you've really crafted down your written response. Hey, your request said this. Basically, repeat it back to them verbatim. That's what we do, and you do how you see fit. We found X number of records that fall into what you're asking for. We can't release these ones for this reason. We're going to redact these ones and release them to you for this reason. We are not going to release these ones, these documents to you because we're not authorized to, or they meet a particular exemption. And you just run through that. And then if there are ones you're going to provide, back to the point about encrypting or not encrypting or the method of getting those to the requester, I leave that to you all to figure out what that is. And again, it might be somebody that's coming in person to come pick them up, or that you need to mail them out, or if they want them electronically, you just find the most appropriate secure means to get that response back to them. But again, you need to have responded in some way within that 5-day window, whether it's in total, hey, responded, records provided, done, check, or it's going to take us longer than 5 days, but we're going to get you your records. And I'm just letting you know, we'll get them to you as soon as possible. That's what you want to do. All right, let me pause here for a second, see what other questions I might have. If everybody's got anything in the chat, I'm not seeing anything just yet, but if anybody wants to raise a hand and ask anything about the stuff I've covered so far. If not, I'll press on. All right, so why do I say it's an opportunity to inform? Well, one, it's a statutory requirement. Law is law, and whether we like it or not, that's just the way it is. But I like to view these as an opportunity to demonstrate, hey, we're with the government, we're here to help. That's not always the nicest way to say it or the most friendly way to say it to some folks. But in all honesty, government transparency, kind of an important thing, and we're public servants. So we deal in information that for various reasons, it is something that, residents, our citizens do have a right to see. So we want to show that we're doing our jobs and we're doing it properly, and we adhere to the letter of law within our particular agency. So it's an opportunity to demonstrate that. And it's also an opportunity to educate them on what you do, what you can do, what's real, especially for the media folks that like to request things. Sometimes you get requests that just, okay, you obviously do not know how our agency operates or the kinds of data that we actually take in and day out. And it's an opportunity for you to inform them. That way, maybe you prevent subsequent requests that are similar and perhaps outlandish. So there's an educational piece to it, but I think the transparency piece is most important, as well as just demonstrating that you're being good public servants. As I said, if a request is unclear or it doesn't quite provide all the info that you would like to see, here's a crazy thought. Engage with them. Email them back. Pick up a phone. Call them. When I've been on the other side as the requester, so those are some of the best interactions I've had, is when folks have been willing to go, hey, call me about this request. I'm not real clear on what you're asking for, but I am happy to help you if you'll just be a little more specific. And I really appreciate that. And then I'm able to drill down and figure that out. When you can, I highly suggest you have that level of engagement because it'll save you a lot of heartache if down the road somebody wants to come back and complain that you weren't responsive within the 5-day window, or the response wasn't to the letter of the law, or whatever the case may be. If you're fostering that good intended communication, I think that goes a long way towards fending off some of those kinds of pushback. Let me see if I see a couple more questions that dropped in here. Yeah, requests by podcasters for a commercial purpose. There is a commercial purpose aspect here, and that's addressed in the guide as well. And what I mean there is you don't have to do this for free. So if somebody's asking for copies, you can charge them for copies. If somebody's asking for a disc or something like that, charge them for what makes sense for your agency, for your time and effort. You just need to be consistent with it. And you can differentiate between something for John Q or Jane Q citizen, Jane Q resident, versus a commercial entity. You can charge more for folks that are obviously commercial agencies or entities. So that is okay. That question, though, is mixing a couple things: commercial, but also this is media, right? that's going to be one where you definitely want to engage with your attorneys on how you field that request, what they're asking for, all those things that I've talked about previously. I don't think it really matters whether they're looking to make money or not. The only way that matters is how much you charge them for the service you're providing, which you are providing a service in fielding these requests. And if you want to be, you want to do this stuff for free, no problem. You're definitely being good public servants there, but you don't have to, because making copies, providing discs, all these things, we recognize they cost money, and it's coming out of your budgets to field these requests. You can pass that along to either residents or even or commercial entities. So that's a valid question in that instance. In terms of the distinction between a podcaster, web-based media versus old school newspapers or those kinds of things, that's where we're getting into that more interpretive. Is it a news gathering organization with the statute? And that's a legal interpretation. Redactions. I see that. Yeah, nervous about releasing juvenile information. I think you're on safe, solid ground when it comes to juvenile information. I think, and I have seen where it's varied with different agencies. I have seen where folks do heavier or then lighter redactions based on information. And sometimes I'm surprised, and other times I'm like, I'm glad they actually redacted that, because I don't think that should be floating out there. So as long as your agency, again, is consistent, hey, we're not going to put out Social Security numbers. We're not going to put out that it was this caller that called us, because I've seen folks flat out redact any of that information. If that's your policy and that's what you think is appropriate, I think you're on solid ground there. So you just have to dig into those exemptions and then really, get a good read from your attorney, and then whatever your policy is, whether it's verbal or you've actually taken the time to write it down, be consistent. And you're probably already getting tired of me saying that. That consistency is key to fending off complaints. Timeline for retaining completed requests on. Ooh, that's a good one. I actually don't know the answer to that. That's going to go into like a records retention or records management type thing, and I don't have that at the ready for you, but I'm sure there is some kind of guidance on how long you should hold on to written applications or written requests for Open Records Act material. That's a great question. I'll circle back after the call and then try to get you an answer out through Mark on that one. That's a great question. Another question. If someone submits an in-person request, going to come back and pick it up. Yeah, again, consistency. Somebody doesn't come back and get the records, you don't have to have them sitting there, in the queue forever. So again, whatever you want to put in place for your policy, I think as long as you are capable and able of fielding that request within 5 days, you have met the intent of the statute. But I will go back and look and see if I missed something in terms of, hey, how long do I have to hold on to it? I've taken the time to build a response. I've taken the time to pull all the records. How long do I have to hold on to it? Because the person said they were going to show up at my window or at my door to pick them up, and they just didn't. That's a great question. I'll see if I can find some info on that too. All right. Oh, those pesky private investigators. They represent sports agencies who submit for background checks. If they're out of state, I don't think they meet the residency requirement. They need to find an in-state private investigative agency to basically sponsor their request. And that would be the workaround. If I were in their shoes, that's what I would do. But if they're an out-of-state PI firm, you don't have to answer it. And you can double check that with your lawyers, but I think that's the case. That's my quick down and dirty answer on that. That's just being they're testing the system, and they're trying to save themselves or make themselves some money by not having to go through somebody local. They should go through somebody local, because the local PI agency in Kentucky, they actually have to meet Kentucky's licensing requirements, and they are actually, for all intents and purposes, considered a resident of the Commonwealth. But great question. All right, and thanks for looking that up in terms of the 3 years for retention. I appreciate that very much. 911 information be released. I might need a little. Here's a good one for me. Good opportunity for me to say that S word again. Specificity. Which particular type of 911 information? Because I'll tell you, just to preempt, I know what I've received when I've made those requests. I've gotten the call logs, the dispatch logs, sometimes redacted heavily, other times not at all. So it's just varied. And then I've also got, the full length recordings or numerous recordings, whatever the case may be, in total. So I've seen it, a variety of ways. Yeah. I've seen it to where the caller is redacted. Any mention of their phone number is redacted. Their address is redacted. I've also seen it where not at all. So I'm not sure that the statute goes into that fully, but you can go through the exemptions with your attorney and determine what your particular locality is comfortable with. But I've seen it in different ways. Sometimes I think it's because the places that are able to redact, it's because they're able to redact. They have more personnel. The places that are smaller shops that don't have time to go through stuff with as fine a tooth of comb, they don't do it. And so again, I think there might be a little bit of interpretation there in terms of the statute, but I would hedge on the side of taking a more prudent, more cautious approach. And when you think it's sensitive and it's something you don't want just floating out there, as long as you're consistent, I think you're okay to redact it. But again, talk to your servicing lawyer about that one. But I appreciate it. All right, I'm gonna keep moving here just in the interest of time, but y'all keep the questions coming, and I'm enjoying the questions, and y'all are keeping me on my game here. I appreciate that very much. All right, so from when I'm on the requester side of things, and for my office here, I tend to be the gatekeeper for we get open records requests in, we start pulling data, we put our team together, we review them, we pull a draft response together, we get our boss to sign off on the final response. But when I'm on the other side of the table, you know, I'm putting my PI hat on, back to the question about private investigators. So say I'm a PI and I'm asking for stuff. I've got a decoder ring on there because sometimes the problem is, and that's why I said be willing to communicate with people. I don't know what your local agency policy is necessarily, and I don't know what kind of specific language you're looking for. So sometimes it's a little delicate dance we're doing here. I know what I'm looking for, but I don't know exactly how to ask for it without wasting your time. I don't want to waste your time, and I don't want to waste mine. And I think if we work collaboratively to do that, we can ease everybody's pain in terms of fielding this request and then allowing you to get back to your real jobs. So being willing to share with folks, hey, I think what you're asking for is this. Here's the kind of language that I think will get you there. I think that can be a helpful approach. But you also don't need to be inundated by frivolous requests. So you don't necessarily have to completely lead a horse to water or hold somebody's hand. But again, depending on your staffing or your how much time you have in your workday, you might be able to help yourselves through being more helpful with these requests by just helping guide people to the right language in the first place. And again, it can be a learning experience or a helpful opportunity to inform about your agency, because sometimes folks think you have everything and you just don't, of course, but they don't know that until you tell them. But at the end of the day, you want to be able to respond in a legitimate legal way and meet the intent of the statute, meet the intent of being a public agency to respond to actual residents of the Commonwealth. So that's what you're looking to do. But I always want to make sure folks are able to turn around and recognize that there are times, and it's not just PIs asking for this, it's legitimate news organizations, it's a law firm that's looking to maybe help out a client with a personal injury suit or whatever the case may be, because they've suffered serious injuries and they're trying to to get some kind of recourse there. There's any number of reasons folks are asking for info. Maybe it's an academic institution that's doing some kind of study. You just never know why folks are asking for this information. And as long as it's a legitimate purpose, it meets the intent of the statute, and you've run through all the different criteria, and you're comfortable with your response, you're on safe, solid ground. But I always encourage folks to put yourself in their position and why they're asking, what they're looking for. And maybe you can save yourself some time, attention, and effort by meeting them more halfway, and then you're able to check that response off just by kind of understanding where they're coming from. All right. Cover some ground here. We've talked about open records requests. We've went over the response requirements, release criteria. We talked about legal review, how to adjudicate them. I encourage that team approach where you can. I've talked about why it's an opportunity to inform. I've talked about putting yourself in the requester's set of shoes to understand why they're requesting this info. I did want to take a second I'm going to scroll through the guide real quick, and then we'll close out with any remaining questions. But like I said, for the guide, if I can get my mouse to work, I'll just go down here real quick. And this one just came out in September. They usually, each time an attorney general changes out, they update this, and then they definitely update it whenever the General Assembly updates anything. So they'll put a little, why they care letter up front. But as you'll see in the table of contents, it kind of goes over the things I just talked about. What are they? What are public records? Who can inspect them? That goes to that residency aspect. Who, in fact, is a public agency, etc. And like I said, this guide, the first 20 pages are what really are applicable for this conversation today about open records requests. If you all ever get involved with open meetings type stuff, that's kind of the next 20 or so pages. What I really wanted to scroll down to, don't let me hurt anybody's eyes here by going too fast. Here we go. Yeah. There's a sample request document here. So this absolutely meets the minimums. What's their contact info? That's the address. That's going to give you an indicator if somebody's meeting the residency. And then they've got a block there to tell you what they're looking for. And that gives you an opportunity to go, nope, that's an exemption, or that doesn't meet, a certain release criteria or whatever the case may be. You can even lay out there like it does there, commercial purpose. Hint, hint, I can charge you for this more than I would a resident. Now be mindful, the charging is for copies or materials that you're sending to somebody. If somebody comes in person, like I said, and they want to view things, you're not necessarily charging them for that opportunity. So bear that in mind. That is a distinction there. And then they actually have a residency statement on here, and you can use that. It's just where it gets into that maybe they don't check the block, or maybe their address doesn't help you understand that. It's when you start trying to demand some version of proof, like a copy of a driver's license, or, utility bills, or, their business filing with the Secretary of State office or something like that. I think that's where there would be a bit of pushback there. But that's a sample request letter you can use. Here's a sample response. You're acknowledging the receipt of their request. You're basically spitting back at them what they asked for, and telling them how you're going to respond and what you can respond with. And then you give them a chance to appeal, and they can file a document like that with the AG's office, for example. All right. Let me see. I think another question popped in here. State of Ohio passed a law. Yeah. I don't know if there's any current conversation about charging for non-commercial purposes. That's a great question. If I hear of anything, or if I come across anything after this call today, I'll certainly circle back and let you all know. But I can imagine these can get quite time consuming. And in larger, agencies or offices, not just in Kentucky, but in other states, you might have an entire staff or team dedicated to this, and you have to pay their salaries to do this kind of a service. So states are going to look at ways to recoup those costs. And, if their legislatures want to do that, I can certainly understand. But I'm not aware of any ongoing effort there because, again, I believe the statutes that I'm referencing today, I think they just talk about the ability to differentiate between a resident versus a commercial purpose, and that you can charge accordingly for copies or whatever media that you're turning back over to them. Again, distinct from somebody viewing in person, where you have to allow them to view or listen or whatever the case may be if they come to your office in person at some point. That doesn't mean they can just come whenever the heck they want. If you want to tell them, hey, we'll pull this data by this date, you come back in here on this date, and we'll put you in this location to actually view the records. So, all right, what other questions do we have? Because I'm going to pull up my, I'll pull up my last slide here so that you have that for my contact info. And then I will pause for a moment here to see what other questions we have out there, or if Mark wants to tee up any other topics or issues that he's familiar with in this arena that I haven't hit upon today.
I believe that you covered everything, sir.
That cannot be the case, but I'll take it. I'll take it, and we'll give people back some time because I know they're very busy. And absolutely, Mark has my slides, and if he wants to send them out to folks, I encourage him to do that. Absolutely, and if nothing else, it'll point you in the right directions in terms of the statutes. Like I said, go back up to the top of this chat and pull down those links to the guide as well as the location on the Attorney General site for any other materials related here. I think that's a helpful spot. and keep the questions coming. If you have anything subsequent, feel free to hit me up. Again, these are just my opinions, my interpretation of the statutes. You need to make sure that you're actually conversing with your actual servicing lawyer on any of this stuff, and especially if you want to put in a particular policy or a process or an actual request or application template. You want to make sure that you've got you got their approval or their thumbs up for whatever you're using. But we're here to help in any way we can going forward. And Mark, I can't say thank you enough for inviting me to do this today. And I hope it's been useful and continues to show our meaningful partnership across the Office of Homeland Security, our Fusion Center with 911 partners, not only within our office but throughout the Commonwealth, to continue to get after things. And I would just encourage you all in your jobs. If you get something that's just, all right, this is beyond the norm. I don't know what the norm is these days for the things that you guys are unfortunately dealing with day in and day out. But if it's really, really suspicious or it falls into something that maybe our Fusion Centers should know about, don't ever hesitate to reach out to us. And if we can help in any meaningful way, we will. There's one more question on here. Let's see. Is there a requirement to allow the public access to request online? I do not believe there is a requirement to do that, but that doesn't mean you can't do that. And there are agencies that do that. Just off the top of my head, I know Lexington, I believe Lexington Police Department, theirs is an online fill out a form process. And then they feel, they'll send you back, hey, we're going to respond within the required time frame. We've got your info. You'll hear from us soon. But you don't have to do it that way. But you can if you want to set up some kind of process to do it that way, that actually reduces the burden on your agency. Very good. Okay. What else? All right, like I said, I think the slide's still up. You got our office number. You've got our Fusion Center at ky.gov. You got our see something, say something line, Eye on KY. If I can ever be of assistance in any way, shape, or form from either my role as the Fusion Center Director or now as the Deputy Executive Director of the Office of Homeland Security, I'm happy to help. Proud of our team here, and I can't thank you all sincerely enough for what you do day in and day out for all of our residents, all of our citizens in the Commonwealth of Kentucky. So I really appreciate the opportunity to talk to you today. It was quite an honor, and just hit me up anytime if you need anything at all.
Thank you so much, Chris.
All right. Thank you, Mark. Thank y'all.